Limitation of liability, willful misconduct, and loss of insurance coverage around the world perspective. Shipping newsletter Legacies. This article has been prompted by a recent decision of the Supreme Court of Canada with respect to the limitation of liability for maritime claims and willful misconduct. Canadian maritime law is in many respects closely aligned with English maritime law and frequently the maritime law of Australia and other Commonwealth nations. In this recent case, however, there was ample discussion concerning the extent to which the finding of both the Supreme Court and the lower court aligned with or departed from decision in a number of jurisdictions. In view of this and in light of the issues raised in the Canadian decision, we now briefly canvass the law on limitation of liability for maritime claim and willful misconduct in marine insurance in 5 jurisdictions around the world in order to highlight the key similarities and differences. Canadian law, Piracomo Incorporation versus TELUS Communication Corporation, 2014. Under the Convention on Limitation of Liability for Maritime Claim 1976, as incorporated into Canadian law, a person is entitled to limit their liability if their conduct is committed with the intent to cause such loss or recklessly and with knowledge that such loss would probably result under Section 53.2 of the Canadian Marine Insurance Act SC 1993. Chapter 22. An insurer is liable for any loss attributable to the willful misconduct of the insured. In the release, the Supreme Court of Canada addressed whether a ship owner was entitled to limit its liability and coverage under its insurance policy. Mr. Foley, the operator of a fishing vessel, released which he owned through his company, snagged a submarine cable while fishing. After he raised the cable that was entangled in his gear, he proceeded to cut it with an electric saw in the belief that it was not a leaf cable. He held this belief on the basis of a handwritten note he had seen on a map in a museum a year earlier. His belief was wrong, and the telecommunication company commenced an action seeking approximately $1 million in damage. The judge at trial held that the chart on board the release was 20 years old, that the cable was seen had been included in notice to mariners and was clearly indicated on more recent chart. Finding Mr. Foley had the duty to be aware of the cable, that he was reckless in the extreme and that he intentionally cut the cable, the judge therefore held that Mr. Foley wasn't entitled to limit his liability, nor was he entitled to coverage under the policy. The Court of Appeal upheld the trial judge. The majority of the Supreme Court allowed the appeal in part. As to limitation, the Supreme Court unanimously held that it was not sufficient that Mr. Foley had intended to cut the cable. Rather, it must be proved that he intended to cause the loss or was reckless and acted with the knowledge that such loss would probably result. Given that it was held at trial that Mr. Foley honestly believed the cable wasn't in use, he could not have intended to cause such loss, the repair cost of an active cable. The Supreme Court held that any lesser task would undermine the convention purpose of establishing a virtually unbreakable limit on liability. As to willful misconduct, this was the first time the Supreme Court was interpreting the concept in the context of marine insurance and, in particular, on the context of Section 53.2 of the Marine Insurance Act. The majority of the Supreme Court held that the test for willful misconduct is of lesser standard than that under the Convention. Relying on Canadian insurance law and certain English law authorities, the majority held that willful misconduct excluding cover under a policy include not only intentional wrongdoing, but also other misconduct committed with reckless indifference in the face of a duty to know. It was held that Mr. Foley failed miserably in his duty to be aware of the cable. His conduct was indifferent to the risk that the cable was left, and the fact that he believed the cable wasn't in use was beside the point. The dissenting justice, however, also relied on English law authorities but arrived at a different view. The fact that Mr. Foley believed that the cable wasn't in use meant that this act could not have been willful within the meaning of the authorities. Justice Wagner opined that subjective knowledge of the risk is a prerequisite for willful misconduct. Consequently, any recklessness must be subjective. The person is conscious of the risk, as Mr. Foley was never conscious of the risk, believing that the act would cause no loss. His misconduct could not be characterized as willful. Justice Wagner was of the view of the majority of the Supreme Court was creating an objective standard, meaning one where it was sufficient that a reasonable person would have seen the risk. To conclude, although Justice Wagner found that both the Convention and the Marine Insurance Act require proof of the same fact, namely knowledge of the harmful consequences of the act, the majority of the Supreme Court of Canada felt otherwise. The English law perspective. The holding of the Supreme Court of Canada in respect of limitation of liability is in line with the position under English law. Interestingly, with respect to willful misconduct, both the majority of the Supreme Court of Canada and the dissenting Justice Wagner rely on English law in part to support their position. Section 55.2a of the English Marine Insurance Act 1906 contain identical language to Section 53.2 of the Canadian Marine Insurance Act, because the 1906 Act was in many respects the template for the Canadian legislation. Not unlike Canada, the question of what constitutes willful misconduct of the insured had been the subject of little discussion under English law, as the majority of the jurisprudence has dealt with cases where the acts of the insured were deliberate. As to the knowledge of the insured, whilst the point is not without some ambiguity, it would appear that the weight of authority is more in line with Justice Wagner's view than that of the majority of the Supreme Court of Canada. For willful misconduct, an element of knowledge is required in most instances, such as the insured realized the risk or knew the conduct to be wrongful. In other words, subjective knowledge or awareness of the wrongful conduct and nevertheless deliberately proceeding to take such a risk. This has also been the position in the concept of English cases concerning the carriage of goods by road under the Convention on the Contract for the International Carriage of Goods by Road, where willful misconduct will preclude a carrier from limiting its liability.